You know, in law, we usually think that for someone to be on the hook for an accident, you've got to prove they were at fault, right? That they were careless. But what if that's not always the case? Today, we're going to dive into two really powerful legal ideas where responsibility isn't just about fault. It's about who should carry the risk in the first place. Sounds kind of crazy, doesn't it? To be held liable even when you did everything right. But the answer is a big, resounding yes. And that's the central puzzle we're going to unravel. This idea of no-fault liability, where sometimes just being careful isn't enough. So here's our game plan. We're going to start with a leaky reservoir back in 19th century England that basically invented a new rule. Then we'll break down what that rule is and its built-in escape hatches before jumping forward to see how a modern tragedy forced the law to get even tougher. All right, let's kick things off. Our story begins way back in 1868 with a case called Rylands versus Fletcher. And trust me, this case sent ripples through the legal world that we still feel today. It's pretty much the origin story of strict liability. Okay, so here's the rundown. There's this guy, Mr. Rylands, who needs to power his mill. So he hires some contractors to build a big reservoir on his land. Simple enough. The problem? Underground, totally hidden, were these old, forgotten mine shafts. The contractors completely miss them. So when they fill the reservoir up, the weight of the water is just too much. It bursts through those weak shafts and completely floods his neighbor, Mr. Fletcher's working coal mine. A total disaster. Now here's the twist. Rylands himself hadn't been careless. He hired professionals. But the court basically said, too bad. In this landmark ruling, Justice Blackburn laid down a radical new idea. If you bring something onto your land that's likely to cause mischief if it gets out, you have to keep it contained at your peril. In other words, the responsibility was his, full stop. But, okay, this new rule wasn't a total free-for-all. It came with a very specific checklist, like a recipe. For a court to apply strict liability, you have to prove 3 key ingredients are there. Let's break them down. First, there has to be a dangerous thing. In this case, it was that huge amount of water. Second, that dangerous thing has to escape and cause damage. Pretty straightforward. And third, and this is the one that gets argued about all the time, it has to be a non-natural use of the land. So what on earth is a non-natural use? Well, it doesn't mean something that isn't found in nature. In legal speak, it means you're doing something special or out of the ordinary with your land that ratchets up the risk for everyone around you. It's something beyond the normal everyday stuff. And this makes it super clear. The water pipes in your house, a little garden pond, that's all considered normal, natural use. But building a massive industrial reservoir, that's a whole different ballgame. That's non-natural. Same goes for storing barrels of nasty chemicals or planting a bunch of poisonous trees next to your neighbor's farm. It's all about the level of risk you're introducing. Now, even though it's called strict liability, it wasn't completely inescapable. The law actually created 5 specific defenses. Think of them as legal escape hatches that someone could use to get out of trouble. Yep, there are 5 key ways out. These defenses really set the boundaries for this powerful rule. So, for instance, if the person who got hurt was actually the cause of the problem, well, that's on them. Then there's the act of God defense. And this isn't just a bad storm. We're talking about a freak natural event that's impossible to predict, like a historic flood. You could also be off the hook if some random stranger caused the problem, or if the government officially gave you permission to do what you were doing. For over 100 years, this whole system, strict liability with its 5 escape hatches, was the standard. But then, a truly horrific industrial disaster in the 20th century made the courts stop and ask a serious question. Should those escape hatches even exist for certain kinds of ultra-dangerous activities? And this brings us to the Bhopal gas leak in India. It was an absolute catastrophe. A pesticide plant leaked toxic gas into the city, causing thousands of deaths and injuries. When it went to court, the company tried to argue using those old defenses, saying they'd taken precautions and it wasn't entirely their fault. Well, the Supreme Court of India looked at the unimaginable scale of this tragedy and said, nope, the old rule is not enough for modern, high-risk industries. So they created a new, even tougher standard, absolute liability. And the principle is simple but powerful. If your business is inherently dangerous, you owe an absolute duty to the community. Period. No excuses, no exceptions. So what makes this rule so tough? First, it takes all 5 of those escape hatches and just throws them out the window. Gone. Second, it's laser-focused only on businesses involved in hazardous activities. And third, this is a game changer. The money awarded isn't just to cover the damages. It's meant to be a deterrent. The amount can be based on the company's size and wealth to make sure the penalty really stings and forces them to prioritize safety. So we have the original rule and this modern, supercharged version. Let's put them side by side to really see how they stack up. This is the final showdown. You can really see the evolution here. Strict liability, born in the UK, gives you 5 possible outs and applies to any non-natural use of land. Then there's absolute liability from India's Supreme Court. 0 outs, 0 exceptions, and it's aimed squarely at those inherently dangerous industries. And maybe the biggest deal is the damages. Strict liability is about compensating the victim. Absolute liability is about compensating the victim and punishing the company to make sure it never happens again. So if you remember one thing from all this, make it this. Absolute liability was specifically designed to slam the door shut on all those legal loopholes. It makes it crystal clear that if you're a company that profits from a dangerous business, you bear the full, total, and absolute responsibility for any harm you cause. You know, when you think about it, the law had to evolve from dealing with a leaky reservoir to a toxic gas leak. It's always trying to catch up with technology, which leaves us with a pretty big question for our own time. As we create things like artificial intelligence, self-driving cars, and genetic engineering, what new dangers are we unleashing? And what new rules of responsibility will we have to invent to deal with them?